Well, an important verdict has come in from the Supreme Court in the Adani-Hindenburg case. We are speaking to Advocate Vishal Tiwari, who was a petitioner seeking a court-monitored probe into the entire matter. So the court has shown full trust in SEBI's investigation. How do you see the verdict?
See, court has passed its verdict upon the material available before it. And as per to my petition, the prayer was for constituting a judicial committee, which was constituted by the Honorable Supreme Court, and judicial committee submitted its report along with the suggestions. And another my concern was that in future, what is the plan so that the investors' money in the share market, the people who are investing in the share market, it can be secured. So those suggestions are very much helpful, and Supreme Court has given directions today in the judgment that government and respondent shall consider those suggestions recommended by the expert committee and shall also take the necessary steps upon them.
So the court has clearly said there's no doubt to question the fairness of SEBI's investigation. You had in fact filed a contempt petition questioning SEBI's investigation in this matter. How do you see this?
See, contempt petition was filed because the SEBI didn't concluded its investigation in the time-bound manner. The 14th August 2023 was the last date for submitting the report by the SEBI. So, for that reason, the contempt was filed, and Supreme Court has today granted the extension of 3 months, that within the period of 3 months, SEBI shall conclude its pending investigations. So, that was another issue. And I never said that SEBI is a biased agency or it is not conducting its investigations in a fair manner, because we are not having any kind of conclusion of the investigations. So Supreme Court has said that when SEBI is already conducting the investigations, then we cannot interfere until and unless there is some other kind of evidence which may prove the SEBI's conduct as biased.
So how do you see the allegations that were raised by some of the petitioners against the members of the expert committee that was constituted by the court? Because according to the court, these allegations are completely unsubstantiated.
See, the allegations raised by some other petitioners, they might be upon some proof or documentary proof, but that documentary proof was not found sufficient to prove those allegations. And upon that, Supreme Court clearly said that upon such allegations without any much credible or strong evidence, we cannot allow them.
So lastly, in a way, the court has also made a remark against the petitioners, clearly saying that petitions filed without adequate research can in fact impact and affect the PIL jurisprudence.
See, whatever directions or observations Supreme Court has given, that will be kept in the mind. But I want to say one thing, that this is for the first time that in the share market some kind of litigations as a public interest litigations were filed before the Supreme Court. And as per to my petition, our efforts were to show and to bring some kind of conclusion so that in future such kind of things shall not happen and the share market shall not be considered as a doubted market or as a risky market. So upon that, I have succeeded up to some steps in that, and in future we think such kind of things will not take place and regulatory mechanism will also be strengthened.
So the petitioner, sir, you are satisfied with this order for now?
See, I am very much satisfied because something has been done, some recommendations for the first time have been there, and some kind of judicial order for the first time has been passed concerning with the share market and concerning with the investors.
Thank you so much for speaking.
Sir, my first question to you would be, what do you think a key takeaway from this Adani?
There are about 5 takeaways. The first is that the Supreme Court has upheld the SEBI report on 20 out of 22 instances. It has rejected the demand for an SIT. It is further stated that there is no conflict of interest. Fourthly, the Supreme Court has taken a view that there is a need for inquiry and investigation into the loss suffered by investors. And fifthly, that media reports are should not be the basis of newspaper reports. Media reports should not be the basis of PILs necessarily. The court has also expressed its reservation and its views on the OCC RP report as also the report of Hindenburg, and said that they would rightly and go by the report of SEBI, which is the concerned regulator, and it has found SEBI's systems and regulations to be robust. Of course, it is said that they must also look at the recommendations of the separate committee, but the point is that it is always essential to keep upgrading regulations to make sure that there is a robust mechanism both for companies which go on the stock market as also for the investors who invest in these entities.
The Supreme Court has disposed of the case today, but what will happen to the 2 cases which are still under probe? And the Supreme Court has set a deadline of 3 months. What will happen to that?
I think that is something which will be in the public domain because the Supreme Court has recorded the undertaking of the Solicitor General that the remaining investigation will be done within 3 months, and that undertaking will result in a report which should be in the public domain in due course and within 3 months.
So don't you think that the Supreme Court has curtailed down the freedom of press today by saying that the petitioner, the PIL, should not be based on only on the newspaper reports?
This was the issue regarding PILs being based on newspaper reports were dealt with way back in 2005 in Dr. B. Singh's case. So it is nothing new. There was a period when Supreme Court was relying upon newspaper reports. The question is, it is not just newspaper reports. Is it an opinion or is it substantive evidence? Now there can be a newspaper report quoting from substantive material and evidence, and if the underlying material exists, there would be no occasion not to rely on such underlying strong material. But if it is only an opinion or a viewpoint, then I would also believe that the Supreme Court's decision that you can't go by people's concerns and anxieties alone, you have to go by strong, hard evidence because an interference in a PIL jurisdiction has consequences.
So what's your take on basically the Supreme Court taking over the investors' interest as a paramount thing? During the hearing also we have seen that. So what do you think that, the Supreme Court has done, adopted a right approach today?
I think whenever a PIL is filed, what are you looking at? Public interest. And therefore, the investor's interest is paramount when you come to look at investigations, especially in the context of people who have invested perhaps their life savings or even taken loans to invest in the stock market.
Thank you so much for talking to us.
That the court has trusted the SEBI investigation. The SEBI investigation is complete in 22 out of 24 instances. The remaining 2 will also be finished by SEBI within 3 months. The court has said that it trusts SEBI. It does not warrant any CBI or any other police investigation as demanded in the 4 writ petitions before the Supreme Court. The Supreme Court has also said that we will not pass any order directing framing of any new regulations as was demanded by the petitioners by SEBI. The Supreme Court has trusted SEBI to do whatever it has to do, and no other material was found to warrant any other investigation. And therefore the matter has ended, and the SEBI will complete, as I said, this 2 instance investigation within 2 months. That's all.
One of the concerns that was raised by the petitioners is that there has been a dilution of the existing framework, regulatory framework to allow mischief. Has that question been answered sufficiently?
The court has answered clearly by saying no further regulations need to be framed. The regulations already there, and if SEBI wants, it can do it. So the court said we are not going to direct SEBI to make any further regulations, and the regulatory framework is fine as of now, and it's up to the SEBI to do whatever it wants to do. See, as I said in the beginning, the court has placed implicit trust and faith in SEBI, because as you know that SEBI is a very impartial body. It has functioned very impartially in the last 50 years, and the court has placed its trust. So there is no way that the SEBI report or a SEBI investigation should be overshadowed or sidestepped by any other report, including this report from Hindenburg, which is a foreign national. And we all know that this Hindenburg is itself claims to be a short seller, and they want to create ruffles in the market so that they can short sell and all that. I mean, that's what. See, it is obvious that Hindenburg's report is malicious. It is intended to create a flutter in the market so that they make their personal profits. That's all. As far as the Adani Group is concerned, it has done nothing wrong, and today's judgment clearly shows that no part of their activities have been found to be under any cloud.